Hello and welcome to Verdictum. I am Ananya Singh and today we have with us Advocate M. Sundari Rami Reddy. After finishing law in 1971 from Sri Venkateshwara University, Tirupati, Sir practiced in Mufassal courts for some years and thereafter went on to do his masters in constitutional law and international law. Sir gave his views in a work titled Legal System is Defaced and Defiled Dharma. He believes that in India, there's need for an alternative legal system that is for and by Indians and free of colonial whims. And today, that's what he will be highlighting on for us. Welcome to Verdictum, sir. It's a pleasure to have you join us today.
Thank you. Yes.
Sir, I would like you to please tell us about the historical evolution of the Indian legal system.
Indian legal system. I will start. You see, Ministry of Home Affairs appointed a committee, that is Management Committee, in 2000. They submitted a report. In that report, Management Committee clearly said that the present system is adversarial system. And in the adversarial system, the judges doesn't have the responsibility of finding a truth. They will act as a referee only. In that situation, they will act what different parties, that is prosecution, defense will say. And the lawyers will be there in between. What they are telling, depending upon that, the referee will decide. He will not go, he is not responsible for truth. So the system is a farce. Present legal system is farce. The present legal system started with Macaulay in 1834, and he came in 34, and immediately he started drafting IPC, Indian Penal Code. Indian Penal Code, he said, but nothing is Indian in it. He never studied what is legal system that was prevailing in India at that time. He came with a British system only. He has codified. Though in England, at that time, there was no codification of any system. Even now, they have not codified the penal laws. But Macaulay came here, he said he made the laws, Indian system is said, but he never studied the Indian legal system at all. He submitted a draft, Indian Penal Code. That's all. From there onwards, several enactments came. In that way, the present legal system has been evolved. But nobody has, they have not studied what was the legal system that was in England. But what is an adversarial system and based upon the utilitarian theory of Bentham, Dicey, all these are utilitarian champions. They never studied what is the Indian system at all. Simply they have thrust upon us the English system. In that way, we have a better, our system is a dharmic system. It is based upon finding the truth. What is the truth in it? Everywhere they will find out, they will try to find out the truth. In that way, our system has developed. It is Indian legal system is the best system to our country.
Sir, there has been a notion that Indians lacked civilized system of law, and so the English needed to make laws for us. Sir, do you agree with this statement at all?
Absurd statement. Absurd statement. Not only the English people, even our Indians, they made such a statement. This so-called main is one of the Sarv-Hindi main is one of the Hindu law also he has drafted. He drafted several laws to our country. He called as an operator of cruel absurdities, our system. M.C. Setalwar, which is immediately after independence, they have appointed the fifth law commission. The first four law commission was in British period. The fifth law commission was appointed by the Indian government. It is our government. M.C. Setalwar was the chairman of the fifth law commission. And he is supposed to study our system and British system and all these things. But he made a worst comment. It would be ridiculous to think of ancient system. He said it is ridiculous. And then he said it is not easy to discover the details of the system of judicial administration, which was in existence. In that way, he said the English system is the best system to our country. Like that, this MP Jain is a person who has constitutional law, data law, here legal history. He gave the textbooks to the country, to the legal field. MP Jain, he said, but in essence, the judicial system continues to be same as it was prior to independence. It is a great system and perhaps one of the best legacies of the English people when they have left us. Then he went on to say, whatever laws existed were uncertain, conflicting, contradictory, and vague. This is how our own people have started implementing the old English system. They never cared to study what was the system that was in existence before British Qatar. Even now, that several people hold this view, not only English people. And the one S.S. Dhawan, retired High Court judge, that is Justice Dhawan, retired High Court judge, and several people have given reply to it. These statements are untrue. It is not for me to guess why they are making this statement. They may be due to sheer ignorance or imperialist self-interest or contempt for Indian culture and civilization, which was part of imperialist outlook which dominated British jurists, historians, and thinkers in the heyday of imperialism. But the effect of this misrepresentation, which has been few parallels in history, was to create false picture of the Indian judicial system, both in India and outside. In that way, this is not only Dhawan made such a statement. Several people who are for the ancient system, Ramadvaris and Shivaraj, such people have made such a statement. So, out of sheer ignorance of the Indian judicial system, the English system has been thrust upon us.
So, would you say that there was a rule of law in ancient India? And if yes, how was it different from that of diocese on which the current Indian legal system is based?
In ancient India, the dharmic system of law was in existence. It was much more better than rule of law. Rule of law came in 1885. Diocese rule of law, it came in 1885. And before that, several thousands of years, we have a better system or a good system to us. This rule of law is consists of three principles: absolute supremacy of law, equality before law, and predominance of legal right. They think that law is in 1885, when the Dicey came into field, it is utilitarian system, the theory was prevalent in England. This I was telling, this Bentham and J. Mill, this Macaulay, all these people are utilitarian theories. Utilitarian theory means the utility for majority people, not for all. Majority people, what is good is the basic principle. But our system is truth. It's not the question of majority, minority, and all these things. If you say, few examples you see in Modern Emperor Kautilya, in happiness he subjects lies king's happiness. In the welfare of the whatever he shall not consider as good, like that. In Ramayana, everybody knows about Ramayana. He has to banish his wife because of the view of his people. The subject of the time, the people said, why do the in Mahabharata there is one Bhishma was there. He was king of Hastinapura, and fisherman's daughter he wanted to marry to his father. But fisherman said, no, I will not give my daughter. Only thing is, if his daughter, my son is going to be born, if he is going to, if you are going to make him, to then he will give. Then Bhishma Pratigna was there. Like that, small ordinary fisherman has to early days, even the present day, this in Tamil Nadu, Manoniti Cholan, a king who was there. His son was riding a chariot. In that, then this cow went to the Raja's palace and rang the bell. Then he came to know his son. Can there be why is rule of law? Why is supreme? That's why our country has been functioning. So this rule of law business is nothing but it's another. It is Westerners. They are experimenting one after the other. So this rule of law is something which so-called they think of rule of law only. Yes.
Sir, as you highlighted the difference between the Indian rule of law and the Western rule of law, could you please also tell us the basic differences between the Indian and Western jurisprudence?
Indian Western jurisprudence means one thing will be clear, that is, this book is Rama Rais has prepared. Rama Rais is Rama Rais. The starting para in this book, I'll read out the starting para. He made a clear distinction between the Hindu jurisprudence or legal system is embedded in Dharma, Puranas, Smritis, and other works on this topic. Dharma is a Sanskrit expression of the widest import. There is no corresponding word in any other language. It would also be futile to attempt to give any definition to that word. This Dharma, it cannot be translated into any language except Sanskritam and Indian languages. It only can be explained. It has wide varieties of meanings. A few of them would be enabled to understand the width of that expression. For example, the word dharma is used to mean justice, what is right in a given circumstances, moral, religion, pious, righteous, righteous conduct, being helpful to living being, giving charity to alms, natural calamities, or other characteristics of or properties of living being, duty, law, and duties. You please repeat the question.
Sir,
Please.
I asked you the difference between Indian and Western jurisprudence.
You see, Indian Maya survey like that for people for all, the dharma is for all. Whereas the Western jurists, they think of majority, minority, all, even though today they are confused. The Western life of Western system itself is 1,000 years, whereas the life of Indian systems is lakhs and lakhs of years. That itself will tell you how how old they are expecting one after the other. You see, in India, the jurisprudence or the legal history or legal system is a matured one. This is the Shivaraj S. Fuchenwar has explained very beautifully. In villages, the local uh, uh, people decide for themselves all the disputes. Even today, I tell you, even today, the 90% of the disputes are settled in the village by themselves. But it is disturbed. It is in a disturbed way. Only 10% or so they will go to the court. So how the 90% of dispute is settled is not at all studied by our legal luminaries. It was concerned with all matters. Village councils dealt with it. The higher level, if the village council doesn't settle the dispute, then only one or two matters it will go to the court. Here, the present legal system had its origin in the dominant philosophy of the British of those days. It is based on the notion of arching state, where a single monarch or a power had all the power which is indivisible. All the powers devolved from top to bottom. That is, under English jurisprudence, English rule of law, under English system, every law is from top to bottom it will come. But whereas in Indian legal system, this will go from bottom to top. That is, the small level village people will sit and decide the matter. If they fail to settle, then it will go. Moreover, here, the present Indian system, there are several people, there are 5 or 6, 7 people will sit together. Everybody will openly will discuss. It is a known way, and the decision will be via media also they will decide. Whereas under the English jurisprudence, this yes or no will be there. Either this man or that man. There is no via media. There is no scope and negotiation. So Western system is not at all suitable to India. Moreover, Western countries, Britain is a small country. It will not be bigger than Andhra Pradesh also. Country, that too new country, 1,000 years old. So they will not understand. There are people of different people, different variety of people, different castes, different guilds are there. Such things will not be there in the Western societies. So this the the Western system cannot be implemented at all. Moreover, uniformity is the basic of the Western system. But in our country, uniformity is not there. There, small country, small group of people, they can have uniformity. But here, where heterogeneous people, that is different variety of people are there, different variety of, you see, or a classic example I tell you. In marriage, in Hindu law, uh, we can have, man can have any number of wives. Like that, similarly, the woman can also, in certain parts of this country, can have no more than one husband. The family itself, 4 or 5 brothers are there, but there will be one wife. So like this, the variety of systems is there in this country. So in this way, the system prevails in this country.
Sir, can you please highlight the judicial system of ancient India and what are the differences between the courts of today and the courts that existed back then?
Courts of today is no courts at all. They don't have the responsibility to find out the truth. Then calling them as a court itself is a misnomer. It's a misinterpretation. Somewhere too, when you didn't find the truth, then what is the purpose of the court? They will have, they will sit, they will, in 2 people or 3 people will come and they will prove the evidences, and the evidences will be on the third person. The trial will take place in third people language, and the third party interference is there, that lawyers will be there. Is whatever lawyers feel, they will upon the time and depending upon the purse of the people, they will engage a lawyer. Then they will present the case. The judge doesn't know. It's a blank in his mind. The Western jurisprudence expects the lawyer, the judge should be free from all these things. He will not have anything in his mind. He will be referee only. If he says no, he is unknown to the parties. So in that way, Western courts will function. In today, Justice Management Committee said that criminal cases, civil cases, most of the cases, 90% of cases, nobody can tell what it is true. Depending upon the majority, minority, they will decide. Depending upon what the advocates will represent, he will view just like this way. This advocate has argued better. This advocate has argued better. Then the judge will have. He will close his. The logo. He will close his eyes and he will decide. So, what is the meaning of this present court? It is not a court at all. I don't know, call it as a court. The way in which we are functioning is that sheer farce. It's only for our satisfaction we will call it as a court. And nobody will say what is the truth in it. So this is how we are functioning. But you ask what is the Western, the Indian system of the courts. Indian system of the courts is different from Western system. Indian system, as I was telling, a small group of individuals in that village are known to people everywhere, and they will sit together and they will ask parties also. There will be mediation, there will be negotiation to settle this dispute, and everybody will be happy. It is settled in in their presence, and it is settled negotiation, and somehow at times this way, that way, that way, they will something like that. This way, that way they will decide, and even a third person can intervene in the present system, the old system. Whereas in the present system, nobody, what is the relevance, whether this man has the relevance, whether this evidence has to, what is the weight of the evidence, and all these things will be there. They will be there. Similarly, if anything goes to the higher up, then the King's Court will come into play in the ancient system. King's Court also, King is not a monarch. The word King itself is a misnomer. Our Raja system is a different. Then he will also have a council of ministers. He will have advisors who is known to who is well versed in the legal system. But whereas in the present system, the judge may know, may not be knowing, he may be ignorant, or anything will tell. But in the old system, the advisors will be or well versed in the legal field. So this is where the old system used to function. Old system also, if you see the textbooks, they will have all types of the hierarchies and the presentation of the plane and the reply and the evidence and all these things will be there. All these things are dealt in several textbooks. Legal, this Ramadho is really he was great enough. He has explained the whole system in a how why is this sloka, why is this system, which branch of law is taken here, like that he explained. Like that, similar to this, several people have explained. It is not the question of knowing the law, the whole system. It is the question of implementation. Whether we implement a present system or old system is the question thing. The other thing is, inquisitorial adversarial system is the worst system in the earth. There is another system called inquisitorial system. We are following adversarial system, otherwise called common law, because we common law countries, we are one of the common law countries. We follow the common law. That is adversarial system. Whereas in inquisitorial system, they have to find out the truth. France, Italy, Germany, and so on, in these countries, inquisitorial system is followed. In the inquisitorial system, judge has got the responsibility to find out the truth. So, in this way, the whole system is a different, really it is thinking. Everybody is talking what judicial or reform, but nobody, very few are going to the truth of it.
So you talked about kings administering justice. So was there a code of conduct prescribed for kings when acting judicially, and was it stricter than what it is on today on the justices or the judges?
You see, our history is, everything is now written by the Martian Westerners. They have distorted history, I can think. The king system, the Raja system, I don't call king. King means only British king system there. Under the British king system, king can do no wrong. That means king or his on his behalf, his juniors, anything will be done, is immune. So king can do wrong even if he shoots his wife or some third person like us. Nobody can question them. He has given the rights. That's why rights have come. It is a source of rights is the king. king is a monarch. So this is the Western system. King can do no wrong. That proverb or whatever we call, that it is now still, even today it is practiced. That is the basis of rule of law also. Daisy or whatever we call. Macaulay. I call Macaulay is the main person. This king can do no wrong concept. Everybody they have accepted. It is coming like that. But under Indian judicial system, king is only custodian of law, guardian of law. Dharma is supreme. Dharma is the it rules everything. The Brahmins, they used to interpret the law, but nobody is the Brahmins or this Raja was supreme. Raja has to bow his head before Dharma. He is not at all, as I was telling, the common man is supreme or Dharma is supreme. He has to bow his head before the Dharma itself. So, in that way, he used to behave in this country. This Swami or the Maharishi Aurobindo has beautifully narrated what is Dharma, what is king. The greatest sovereign and king was Dharma. The religious, ethical, political, juristic, customary law, organically governing the life of the people. The king was only guardian, executor and servant of the Dharma. Change it to see to its observance and to prevent offences. Serious irregularities. He himself was bound. You see, Raja Dharma, there is every ancient text speaks of Raja Dharma. There, he is bound. His rules and regulations for Raja Dharma is more stricter than ordinary people. So he is not at all monarch. You see, in the present system, Mahatma Gandhi, he said, it may be unparliamentary, but his own language, the condition of England at present is pitiable. I pray God to God that India may never be in that plight. That which you consider to be mother of parliament is like a sterile woman and a prostitute. This is the words of Mahatma Gandhi. He said about liars, liars are immoral. If there is anything good in them, it is because of the goodness in that man itself. Otherwise, liars are immoral. In that way, Western kingship and the Indian kingship and the Western Parliament, it's a function. We have adopted same Parliament. What Gandhi envisaged against it, we have adopted parliamentary system. So the king in Western countries is different from Raja in our country. That in our country there was, if there is anybody who is a despot or cruel king, immediately used to overthrow them. Not that he can do no wrong. Always Dharma will be there. And for safeguarding Dharma, there will be Rishi. Rishi system is there in our country. Rishis used to, their Rishis they used to make the laws. The parliament was not, king was not making the laws. Parliament was not making the laws. It is the Rishis who makes the laws. In this way we function. So Rishis, they are not concerned about anything except Dharma. So Dharmic laws they have prepared. So like that, the king is not independent in our country, whereas in Western countries, king is a supreme.
So, talking about the kings, as you talked, the king can do no wrong. You highlighted on the concept was the king and his kins immune from punishment for offenses in India in the ancient times? And how can you compare the immunity and privileges of then and now?
In our country, there was nothing like king. There was only Raja. The two words are different. The English people, they have mixed everything. This Raja, he was not at all immune at all. He's more, immunity doesn't extend to Raja. Rajas were more, what I say, they are more than ordinary subjects. They have to be more careful. Their reacts are scrutinized by everybody. They are liable for their reacts. So king was not at all immune from the any acts done by them. Their acts are questionable and they are bound by the law, dharma, whereas Western countries, the king is supreme. He is not liable. Immunity in the Western countries is applicable. In this country, immunity is not all applicable. You see, for example, I was telling out about the Bhishma or Ramayana or Manu Cholan and all these examples. King was not at all immune. If the king was immune, if the Manu Cholan, why he has to execute his own son? So it was the rule of the dharma. So king was not at all immune from the his acts.
And sir, is there any difference from the immunity and privileges that existed for the kings back then and to what exists for now in the system?
The king, again, we might say Raja. The king in Western countries, he is having all privileges. But Raja in this country, he didn't have any privilege at all, except he had to rule, he had to administer dharma. His role only administer dharma. Only thing is, nowadays, these people have depicted Raja, all these ornaments and with this thing only they have exhibited or they have depicted the Raja. Raja was, he was not at all of that type of nature, no immunity for him, no, all these things he was not at all, he was bound by the dharma only.
Sir, it is to be noted that there were no consolidated laws like the Indian Penal Code or CRPC in England. And for a consolidated law was made for India and then for the English. Do you think Indians were part of an experiment? What is your view, sir?
When Macaulay came to India, he drafted the Indian Penal Code. In 37, he submitted. It was accepted in 1960 or so. That is after First War of Independence. That is in 1857. We had the First War of Independence was there, and the English started one by one. They are bringing the Western laws. But this uniformity and codification was done by the Macaulay and others. Even today, Indian Penal Code issued for India, but British Penal Code is not there. Even today, there are several here and there laws may be there. Moreover, there may be judgment laws. This common law or adversarial system, all these things are judgment laws. And that means there is nobody like Smriti, Dharmaka text. Such things are not there. That's why whenever the problem comes, the judges will decide, and that will become law. That was the Western system. Here, that system was there. Pakka judicial system and legal system, legal principles are there. That is, it is not in the form of codification. Codification is not of our concern. It is not good for the country also. It may be good for the small countries like Great Britain. In our country, there are variety of people, variety of problems, variety of persons are there. So diversity is the unity in diversity is our motto. So whatever suits is our shastras. Even ordinary people who doesn't know anything about literacy, ordinary coolies also, they will speak of dharma. If you ask them to explain, they may not be able to explain. So in that way, to that extent, we have percolated. Dharma has percolated to the ordinary people of this country. It is the genes of this country. So codification and unification is not at all necessary in this country. This codification and unification is result under the legitimate laws is resulting havoc in this country. So in that way, codification and unification is not at all good for this country, and the parliament is law-making system is not good. The parliament, they cannot make for everything. The identity problems, they immediately jump to make a law. They cannot visualize everything, whereas our Shastra, Dharma Shastra visualizes all these things and makes the laws. So, like this, the codification, unification is not part of our culture or dharma of this country at all.
So, oftentimes now we see the courts delivering split judgments in many important cases. So, the most recent being the hijab row and the marital rape judgment, which was pronounced as split. Is there any remedy for this in the ancient jurisprudence? What is your view on courts pronouncing split judgments? Please also highlight on that.
This split judgment business will come because of the judiciary or present system. The present system of judiciary or law is they didn't have any basis at all, no philosophical basis, no ideological basis. The laws means there is no enactment regarding hijab or the marital rape, all these things. This hijab, the parliament also, for 100 and odd problems will come in this country. For everything and anything, parliament cannot make laws. Similarly, judges, they will have their own philosophical background, ideological background, or they may have anything at all. Blank mind will be there. Then whatever their perception, they will get the judgment. Out of some people will go for dissenting, this thing, that thing, that. So depending upon their perception, not based upon any law. Then whatever they say, they will become. Majority will say that will be law. Then, if you come to ancient system, what is good for our country? Ideological basis will be there. Philosophical basis will be there. If you say so-called marital rape, you take the, for example, marital rape. What is the question of marital rape at all? That word itself is it's not suitable to this country. Moreover, hijab, marital, such things may happen one or two rare cases. Rare cases, highlighting the rare cases and try to make this law. There will be always one or two aberrations will be there. Better to ignore such things instead of making it saying, making them very big and trying to find the solution for it is not a that good thing. Second thing is, if morality is raised in this country, there will not be rape at all or marital rape at all. Because if society doesn't have any ideology, philosophy, what is the philosophy of this country? I have to, man has to rise to the level of moksha. That is my real nature. He has to raise from bottom. We have to guide them to raise to that level. So, in this materialistic world, there is no philosophy of anything. This Theodore Else, he wrote a book, beautiful book on Lokamanya Bala Gangadhar. He explains what is Indian philosophy, what is Western philosophy, beautifully explained, and how he calls Western Westerners, the British and Westerners, civilized Westerners, not the civilized. English people said we have to civilize. We are civilized country. You have to civilize the Indians. So instead of that, he said, let us civilize the West with the Indian philosophy. So this marital rape and all that things, let us better to ignore, or everybody will call upon their perception. They are giving judgment. For most of the judgment, there is no. See, I will give you a classic example. In Chennai, there was a blast in one of the one building. In that, 12 people died, and the culprits were caught. They confessed. Trial court convicted them. High Court convicted them. It went to Supreme Court. In Supreme Court, they said RDX was placed to blast the building. From the prosecution failed to source of RDX. Prosecution failed to find the source of RDX. When the culprits confessed, trial court convicted, and the High Court convicted, and now RDX from where they might have brought somewhere. In what way we are concerned? Supreme Court acquitted them. What a funny judgment. So this is instead of this type of minority judgment, all this will come depending upon the. There may be communist judge, there may be some other judge, there may be like that. Ideology has come. This country has doesn't have the ideology of its own, except masses where the 90% of the settlement disputes are settled even today. That has to be studied and edited. So.
Sir, will I be right in saying that in the ancient times, there were no split judgments, because usually the bench or the justices that were there were in odd numbers rather than in even numbers? Is that correct, what I'm saying?
In ancient times, in dispute will not be decided by single judge. Always a jury will be there. Nowadays, all lower courts, if you see the trial court or at times High Court, single judges are there. There is no other judge. Moreover, in the course of writing judgments, the judge may have several doubts. He may have, but he cannot ask the person to clarify it. So, judges, he will give his own judgment on whatever he feels right. So, in that way, the present system is going on. the world system, jury system was there. There is no scope for dissenting judgments because everybody is based upon dharmic. They are well versed in dharma shastras or well versed in the laws of the ancient country, and the laws will be discussed and the judgment will be pronounced by the juries. They will not decide the case, but they will present before the king's court, the Raja's court. So depending upon the opinion of the judges, the Raja will pronounce the judgment. So there was no scope for dissenting or null and this. Whereas in the present system, everybody will be, it is free for all. So the system is functioning in that way.
So, my last question to you would be, do you think the courts are on a quest for discovery of truth today? How was this taken care of back then?
The courts are not in the picture today. They are not trying to find the truth. The parliament is not trying to find the truth. Everybody was in their own realm. The courts, in the adversarial system, there is no scope for it at all. If they switch over to the inquisitorial system, that's why, as in the ancient system and also present adversarial system, at least you implement the inquisitorial system. At least you go to France, you go to Italy, you go to Germany, or some other African countries, which are some of the countries where British doesn't have a say, which is not Commonwealth countries. Study those things. At least implement the inquisitorial system. At least in that way, somebody interested, the courts are trying to find the truth. But in adversarial system, no, there is no possibility at all to find truth or to judge the good or bad, whatever may be. So in that way, the courts are functioning, legal system is functioning, the justices are functioning, and the lawyers are functioning. In that way, one thing I tell you, in the old system, this type of laws is not there. This taking money and going for I will get the justice for you. Where is the what is these two things are contrary. So lawyers, the courts, the whole functioning of the judicial system is far. There is no word for me to tell it. Yes,
That was very, very insightful, sir. Thank you so much for joining us, sir, and enlightening us on such an important topic. And
right.
with that, I, Ananya Singh, thank you for watching Verdictum. Don't forget to subscribe to our channel for more such content and download our app on iOS and Android for authentic legal news.
Thank you. Thank you. Please.